I just returned from Virginia, where Index Exchange's CEO, Andrew Casale, testified on the opening day of the United States Department of Justice's antitrust trial against Google. The trial assesses alleged antitrust abuses by Google in the open web display advertising market. This case has the potential to be uniquely impactful in ad tech, and I know there's a lot of interest, so I would love to discuss in more detail. So what is this case about? In January 2023, the United States Department of Justice filed suit against Google claiming breach of antitrust laws. Please note that this trial is separate from the search trial that concluded earlier this summer. In this case, the United States Department of Justice's suit claims that Google's anti-competitive behavior creates barriers to entry, which reduce competition in the ad tech ecosystem. The primary remedy at issue here is what's called a divestiture order. In particular, the United States Department of Justice is asking the court to order Google to divest its advertising businesses, including, at a minimum, the Google Ad Manager suite, including both Google's Publisher Ad Server DFP and Google's Ad Exchange AdX, along with any other structural relief as necessary to cure the anti-competitive harm. Google is being investigated for antitrust abuses or abuse of dominance in many jurisdictions worldwide. This is one of the many cases we may see on this matter, but in some ways, it's the most important. There are two reasons this antitrust case is particularly interesting. The first is because of that requested divestiture order and the potential impact an order like that may have if granted. The second reason is the trial location. The United States is a huge and enormously important market. The scale of the market impacts this case and makes it particularly resonant. Let's talk about some of the highlights from the start of the trial. Ms. Julia Tarver Wood delivered the opening for the U.S. DOJ. The U.S. DOJ centers its case around four legal claims: that Google monopolized the market for publisher ad servers, for ad networks, and for ad exchanges, and that Google unlawfully tied its publisher ad server together with its ad exchange product. Wood outlined the monopolist playbook as possessing three characteristic behaviors: control the competition, control the customers, control the rules. Wood closed noting that the plaintiffs are not here to punish Google for their success. She said Google is not here because they're big. They're here because they use their size, in Wood's opinion, to crush the competition. Wood poignantly commented that one monopoly is bad enough, but a trifecta of monopolies is what we have here, referring to DFP, AdX, and GDN. Ms. Karen Dunn provided the opening for Google. Dunn highlighted that Google ushered in transformative innovation that's helped millions of people. Google invested to make these innovations function effectively and efficiently and safely. Google argued that the US DOJ's case will fail because they won't be able to prove the market, and that the US DOJ is, quote, gerrymandering markets to create a market for the purpose of this case. Obviously, I'm biased, but Andrew Casale was an excellent witness for the United States Department of Justice on day one of this exciting trial. He brought his particular brand of logic and clear explanation to complex topics which can only benefit this case. I'd also like to take a second to give a nod to the incredibly powerful women on both sides of this courtroom, and importantly, on the bench. Ms. Julia Tarver Wood for the US DOJ and Ms. Karen Dunn both delivered compelling opening statements. Ms. Dunn also advised Vice President Kamala Harris in advance of the presidential debate on Tuesday night. Ms. Justina Sessions for Google delivered an outstanding cross-examination, and perhaps most importantly, Justice Leonie M. Brinkma of the United States Court for the Eastern District of Virginia brings a fairness, a straightforwardness, and an efficiency to her courtroom, while appearing to easily grasp the complex nature of this business. So what are Index's thoughts on this trial? Of course, we can't speculate on the trial's outcome, but we do see this trial as aligning to three core values that we hold to be critically important. The first is fairness and transparency, the second is support for publishers, and the third is choice. Regarding fairness and transparency, Index believes in a fair and transparent marketplace where the technology speaks for itself. Regarding support for publishers, Index's primary focus has always been and will always be to continue serving our publisher customers, helping to optimize their revenue while providing clear reporting on transactions that occur through our exchange. Regarding choice, Index also believes in flexibility and choice. We believe our partners on both sides of the ecosystem, media owners and buyers alike, should be able to choose the partners that bring the most value to their businesses. Choice should always remain paramount. So with all this context in mind, what can we expect as the trial proceeds? This case is unique in part because it's so fast. Some antitrust actions take years. The Eastern District of Virginia is colloquially known as the rocket docket. So while we can't speculate on the outcome of this trial, we are expecting swift action and that the court will rule quickly. We'll be following closely as the trial continues.